If you're an independent artist who's about to work with a producer, or if you're a producer who's going to work with an artist, then you need to have some kind of written producer agreement in place between you before you begin recording. So even if you only manage to agree and understand a few of the key basic points between you, then make sure you get those written down, because that is going to be way better than having no agreement at all. We've noticed lots of independent artists and producers working together without any written agreement in place between them. Now, this can result in disagreements further down the line. The danger is that you'll both have preconceived ideas of what you think are standard clauses for a contract. And these expectations will vary from one person to the next, and certainly from one country to the next. We find this is even more exaggerated for artists and producers who are at the beginning of their careers and probably have minimal experience. Then your ideas of what you think you're agreeing to can vary quite greatly and lead to further disagreements. So understand at least some of the key points between you and get them written down. So if you're an artist or a producer and you want to start recording some music, who actually sorts out the contract between you? Who actually writes it down? Where does it come from? Who's responsible for it? Well, this tends to vary from project to project. I've worked on numerous projects. We've managed artists and producers. Sometimes I'll handle it. Sometimes it's sent to me. Sometimes the label's dealing with it. So it does vary. So I'm assuming that you're going to be self-managing if you're watching this video. So in that case, the first thing that the two of you need to do is you just need to have a conversation about what your budget is, how many tracks you expect to be recorded for that budget, and agree whether the producer is going to be doing right up to the final mixes. Once you've agreed that, then you can start talking about the actual finer detail of the contract and what it is you're agreeing to. And that's what I'm going to take you through in the rest of this video. Now, there's a lot of help and advice online that you can find, and even some producer template contracts. But they tend to be very detailed, and a lot of them are quite focused on major labels and bigger producers, this kind of thing. I'm going to try and go through with you and give you an overview of a real life experience of what it tends to be for self-managing artists and independent artists who won't have big lawyers and are signed to big labels and are kind of doing a lot of this for themselves. So what we find is there's huge gaps in knowledge of what the basic elements of a producer agreement are, or even what it is, the key parts of what it is that you're agreeing to. But don't feel bad about not knowing all of this. Okay, you're an artist or a producer. Why should you know all about music law? And I'm going to let you into a little secret. I know loads of people and have met lots of people in the music industry, sometimes at labels and recording studios even, who don't know the basics of what copyrights are being agreed with which contracts, and certainly with producer contracts. Okay, lots of people just assume that they know it, or they pretend that they know it. And this lack of knowledge, this knowledge gap, is resulting in all sorts of baffling and nonsensical agreements that I see between parties, and they're agreeing different splits and royalty agreements and percentages. And the other amazing thing is that a lot of the time this ended up being of no consequence whatsoever, because nobody was even registering the tracks or collecting the royalties and didn't really understand who was supposed to be paying who and at what point anyway. So it's quite a confusing mess out there for you. I understand it, for people who are self-managing and trying to find their own way and grow their careers. Okay, so hopefully this video is going to help put some of that right for you. I think one of the main reasons for so much misunderstanding of producer agreements tends to be caused by a lack of understanding of what a sound recording copyright is. So let's just try and clear that up. If you write and record a song, okay, you have created two copyrights. Okay, one copyright for the song that you wrote, and then another copyright will exist for the recording of your song. Okay, these are two different things. Okay, so if you write a song, you have created a copyright, which is sometimes referred to as the composition or just the publishing rights. Sometimes you may hear it referred to. And if you record your song, okay, you've created a sound recording copyright. This is totally different to the song. Sometimes you may hear this referred to as the master rights in contracts. Okay, they're two different things. So whoever writes the song owns the song copyright, and whoever makes the recording owns the sound recording copyright. The ownership of the song copyright is unaffected by it being recorded. So for example, if you'd written a song and then somebody else makes a cover version of that song, records a cover version of your song, you will still own the song completely. It's not changed in any way by the fact that somebody else has recorded it. The person who's recorded it, the artist and the producer, okay, they will have their own agreement between them as to the ownership and the rights of that sound recording copyright, okay, but they will have nothing to do with the ownership of the song. That still sits with the songwriter. Okay, so what you need to understand is that a producer agreement is just focusing on this sound recording copyright, the recording that you and the producer are making between you. The song ownership is unaffected by this process of recording it. So when you, as an artist, are talking to a producer about recording your songs, the agreement between you is based only on the sound recording copyrights. That's the backbone of a producer agreement. Okay, the producer will have no automatic claim to any of your song copyrights just because they're recording them for you. Okay, they are two separate things, separate copyrights with their own separate world of royalty collection. All right, the producer doesn't have an automatic right to your songs just because they're recording your songs. Now, having said this, there can be a few exceptions. For example, if you're working with a big producer and you're an artist who's just starting out, then maybe the producer may ask for a share of your songwriting for the privilege of working with them, or maybe you can't afford to work with them, and so that's a way of compensating the producer. And there are certain genres such as rap or hip hop where the producers feel that by them crafting the beats, they have actually written the song with you in some way, and they want to have a songwriting share with you. But generally speaking, that is not normally the case. For most artists and producer examples, it's usually standard that you're only talking about the sound recording copyright. It can also get a little bit complicated if you actually have genuinely co-written with the producer. Sometimes that happens, you've written some songs with them and then you're going to want to go in and record the songs. But that's slightly different, and there will be some extra things in your contract, which we'll talk about a little bit later, that you'll need in there. But it still doesn't affect the backbone of what the producer agreement is, and that is that you are discussing and agreeing terms and royalties revolving around the sound recording copyright only. So this leads us to one of the first key points that you need to agree between you as the artist and the producer, and that is the ownership of the sound recording copyrights at the end of the recording process. Okay, so who's going to own the recordings? Who's going to own the masters? Okay, whatever you want to call them. Okay, that's what you need to discuss, and that's what needs to be agreed in the producer agreement. Okay, so it's fairly normal and standard, I'd say, that the artist will end up owning the recordings at the end of the process, not the producer. Now, the producer does have some technical legal basis to claim a share of the recordings because they're the ones doing the recording. It's usually on their equipment or in their studio and so on. So you want something in the agreement that says that the producer will hand over the ownership or any claim they've got to the ownership of the recordings to the artist once they've been paid and at the end of the whole recording process. And the way this is normally done is there will be a clause in the contract, and a part of the agreement will say that the producer will assign their rights, all of their rights to the recordings, to the sound recording copyrights, over to the artist once they have been paid. Okay, that's fairly normal. There are some circumstances where that may not happen, and there can be some exceptions, but generally speaking, for most artists who are hiring a producer to do their recordings, the artist should end up owning the recordings at the end of the process. So now you know the basis of what a producer agreement is, and it's all about the backbone of the sound recording copyrights. Let's have a little look at the next thing that you're going to really come to, which is how the artist pays the producer for the work they're going to be carrying out. So generally speaking, there's two parts to the payment. There is a fee of some kind, and then there's a royalty based on the future earnings from that recording. So there are a couple of things to think about. Maybe if the artist can't afford a large fee, or the fee that the producer wants normally would work for, perhaps they could agree a slightly larger royalty percentage further down the line. And also maybe if the artist can't really afford to pay what the producer would normally expect right at the beginning, perhaps they then agree that if the recordings go on to some success or they get signed to a major label further down the line, that perhaps there could be a future extra fee or payment to the producer at the time that happens. So there's a couple of little things to negotiate and think about. But let's just have a little look at the fee part first. Generally speaking, I would say it's preferable to pay a one-off fee to the producer and to not have a daily or hourly rate that can go on open-ended and can affect your budgeting. I would also say that you want to check that it includes any studio costs or any other hidden costs that you haven't discussed yet. So talk about these things and agree. Don't make any assumptions. It's also quite usual to discuss whether or not the fee that the artist is going to pay to the producer will be recoupable from the producer's future royalty income. So what that means is that as the artist makes money from that recording in the future, there should be a royalty that they should be paying to the producer. And we'll get onto that royalty explanation in a little while. Okay, so there should be a royalty generated for the producer. But what the artist could do is recoup the amount they've already paid to the producer. So they won't pay the producer's royalty just yet until they've clawed back the amount that they've already paid them up front as a fee. And then once they've got that back, then the producer's royalty will kick in. Okay, does that make sense? So that's what can happen. That's called recouping, in which case the fee really should be called an advance. So there can be different languages that you may see in different agreements. They could call it a fee, they could call it advance, you may see talk of recoupment, but you should probably know what this is all about. Some countries, it's really standard that it's just expected that it's recouped back before you start paying the producer royalty, and other people think, no, it's not standard at all. The fee's the fee, and the producer's royalty sits on top of that. It's not part of the same thing. So there can be misunderstandings here as to what both parties may assume it should be. Sometimes you may discuss that we'll recoup 50% of it, and we'll sort of meet halfway as a compromise. So have a little think about this. I tend to find that these conversations happen more the further up the food chain you go. So once you get to kind of like major labels and more experienced producers and so on, then these kinds of things start appearing in contracts. If you're just both starting out and you're sort of managing yourselves and writing the agreement between you, and you're talking fairly small fees and probably fairly small incomes for the royalties further down the line, then maybe it's probably not worth overcomplicating things by talking about recouping and so on. Maybe just want a fee, be done with it, and a small royalty should there be profit further down the line. So, but I just want you to be aware that these conversations happen, and if you see it in the contract, then you'll understand what it is. Now we're going to look at the second part of what it is that the artist pays to the producer for the work they do, and that is the future royalty income. So the artist will agree with the producer a certain percentage of the income that's generated, mainly from sales, distribution, streaming, that kind of thing. So this is sometimes referred to as points or percentage points. That may be the sort of language you might have heard, but this is what it means. The artist agrees with the producer that as income is generated further down the line, that they will give the producer a small percentage of that money. Now this is where it can be a little bit confusing, especially for self-managing, emerging independent artists. It used to be that the producer agreements were generally done by the major labels and signed artists and big producers, this kind of thing. And what would happen is the label would be the one that collects all the money in, and they would have an agreement with the artist and pay the artist their royalty. And often they would also be hiring the producer. And so they would agree a percentage with the producer based on the income that would come in. Now they would agree this percentage in relation to what would be the suggested price of the recording when it went to sale. So like the recommended retail price or the price to the dealer. There'd be various descriptions for this. So you may have heard of something called PPD in contracts. And essentially that's what it was. It'd be like the sales price of the record once it went on sale. So the producer would generally get something like 3 to 6%, that kind of an amount. And it was based on the sales price of the final recording. However, these days, many independent artists are self-releasing. So they're controlling their own distribution and therefore collecting in their own sales income. So a modern way to try and calculate the producer royalty is to base it loosely on this 3 to 6% that it used to be in the older days, and you then calculate it on the artist's income minus a few costs. Now it does vary as to what costs will be deducted from the artist's income before the producer's royalty is payable, so you do want to negotiate that and just make sure that you've agreed something between you. But generally speaking, the percentage usually equates to something like 15 to 20%. So when an artist is going to self-release their music and there's no sort of big label involved, then that's the kind of percentage that I tend to see in a lot of these contracts. And it's quite common now in a modern producer contract to see both of these scenarios detailed underneath the explanation for what will be the producer's royalty. So you'll see the PPD of being sort of 3 to 6%, and then you'll see the sort of 15 to 20% a self-release scenario. Okay, so both of those scenarios will generally be detailed now on most of these producer agreements. So that covers the main things that you're going to need to understand if you're going to hire a producer. Okay, that's the backbone of a producer agreement, of all the things that we've covered, and you're going to need to reach an agreement on those and understand them. Now I just want to come back to one of the things that I did pick up on earlier, which was the songwriting. So remember, the producer is not entitled to your songwriting copyrights just because they're recording your music for you, okay? But your producer may have genuinely co-written your songs with you, or one of them. So they may actually be listed as a co-writer on one or more of your tracks. So if this is the case, then in your producer agreement, you will want a clause which just allows the artist to be the person who makes the decisions on what happens with the songs. A clear example of this is if the artist wants to sell a sync of the song and the recording, say to a TV company for it to be used in a TV show, then you don't want to have to keep coming back to the producer to get their agreement and their permission each time. So you can put something in the contract that just says that the producer is happy to agree to license their share of the song on the same terms that the artist is licensing theirs. And that way it just makes things a little bit easier. Okay, so you need to do that. Now, this doesn't change though how both the artist and the producer collect in their own share of the songwriting. So they actually will have their own publishing income that comes from the song and from the songwriting, and they will collect that themselves, either through a publisher or through their PRO. Okay, it's totally unaffected by that. All they're doing is just giving the artist the permission to make the decisions. That's all it is. Then beyond this, there's multiple sort of smaller things that may get agreed in a producer agreement. And I'm just going to touch on a couple of these. It's quite likely that you're going to see an entitlement for the producer to be credited and identified as the producer of the recording. So this means that the artist is obliged or has to list the producer's name as the rightful producer of the recording whenever they list the recording anywhere or they try to sell the recording in some way. Okay, that's quite a common thing. It's also quite usual to see that the producer is entitled to take away their credit if they no longer want to be associated with the recording, especially if the artist has then taken the production and then used another producer to do some work on it. The original producer may no longer want to be associated with it, depending on how it goes. So that's usually what you'll see. It's the right to be credited, but also the right to withdraw themselves from it if they wanted to. That touches on one other aspect that you might see in these contracts, is that if multiple producers get used, and this does happen sometimes, especially in pop music, a song can pass through many writers and many producers, you may see that it will talk about how the royalty that we spoke about earlier, the producer's royalty, will be shared between all of the producers that are working on that track. Otherwise, obviously, the artist could end up paying, say, 5% PPD to one, and then 5 to another, and 5 to another. They could end up paying 50% of their income to all these producers. So that doesn't happen. What happens is you tend to have a certain fixed amount, and you'll share it between the producers that are working on the track. Often you may see that happens, that the producer will want to have at least a minimum guaranteed percentage. So they might accept 5% PPD, but they won't go below 2%, even if multiple producers are there trying to share it out. You may then also see a variety of other finer points in some of these producer agreements, and lots of them are trying to clarify what could happen in different circumstances and scenarios in the future with regards to royalties, and clarify certain liabilities to each other and these kinds of things. Generally speaking, the more that lawyers are involved, then the greater the final detail becomes of some of these consequences and some of these points that get thrashed out. But generally speaking, I say that if you're just starting out and your fees are fairly low and the recording's likely to sort of have low to medium success, I suppose, in the long term, then a lot of these finer details are a fairly low financial consequence to yourself. So the main thing is that you have something that covers the key points that you both fully understand. Now, hopefully that's given you a good overview of what a producer agreement is. If you're going to try and attempt to create your own one, then there are things online that you can have a look at. There are even music law firms and music organisations that might offer template contracts that you could use as a basis to begin drafting something for yourself. Just bear in mind that obviously everyone's got a different idea of what they think might be standard, and certainly from one country to the next that can vary quite greatly. And also some of these contract templates that you're going to see may be written from the perspective of a producer or from the perspective of an artist, and they might have an angle of protection that may favour one over the other. So just be a little bit aware about where you're getting these things from. But the main thing is that the two of you need to have something that you both understand. I'd say try to keep it fairly simple, that it's workable for you, and then you can sign that and then move on to what it is that you're both good at, which is making music. Hope that's been useful for you. If you like this video and you found it useful, please don't forget to like, subscribe or share, and good luck with your music. We'll see you next time.